Good evening, everyone, and happy Monday. Happy winter solstice. It is the longest evening of the year, and we are moving on to brighter evenings ahead. So, today I wanted to talk about time of the essence, what it means, why attorneys remove this language in attorney review, why attorneys serve it sometimes, and how it could impact you if you are in a real estate transaction, how you can use it to your advantage, and what the realities of it are. So, time of the essence is a legal term that gets applied to closing dates or contract dates. In real estate, it's usually related to the closing. When you're buying a property from a bank, like an REO property, or if you're buying a bank from someone who has picked it up as an investor, you're going to be dealing with closing dates that are made of the essence. The closing date is called for time of the essence. And the reason for that is because the sellers want to confirm and know ahead of time when they're going to close. They don't want you to be delayed. They want to close on the date, and they want it to be so that they have clarity. Now, it's also a tactic to be able to kind of charge you money if you're late, because what happens is if you miss that date, the sellers can hold you in breach of contract. That's what happens when you make a closing date of the essence. If you miss it, you can be held in breach. And so what banks will do is sometimes they'll decide they don't want to sue you and you've been far enough along in the contract. You've been doing everything else that you're supposed to do, but they would like to maybe charge you $100 per day for being late. So that can happen. It depends on the parties involved, their attorneys. You might be able to argue your way out of it. It really all depends on the circumstances. So most of the times in a residential real estate transaction, attorneys will say that the closing date is not of the essence. And the reason for attorneys doing that is because what if you missed the date because you had an emergency? What if you miss the date because your lender's not ready? In a regular residential real estate transaction, if you're not buying cash and you're purchasing a property with a loan, and even if you're the seller, there could be things that come up that push the closing date out just because things need to happen. Third parties need to provide certain paperwork. It's very likely that the date will have to move. So attorneys remove the language that this closing date is of the essence, and they do that in attorney review. Now, when you are in a residential transaction and that language is removed, you're going along in your transaction, and then all of a sudden the closing date is missed, and there may be a valid reason why, but then after that valid reason starts to become really dilatory. Like, you can tell that there's a delay and it's on purpose, or the other party just doesn't have any urgency. You can really feel when it's appropriate to start to really get anxious that the other side isn't doing what they're supposed to. You can then serve time of the essence, and you can make that closing date of the essence, and you can say, hello, other person, you're not performing. And because of that, and because you've already missed the original closing date, we are going to now make this new date that you have to propose of the essence. And the courts generally assume that the reasonable amount of time to give someone to make a closing date of the essence is somewhere between 7 and 14 days, depending on the circumstances. It can't be 1 day, it can't be 3, but it could maybe be 7, it could be 10, it could be 14, it depends. But you do have to give a reasonable amount of time to the other side to get themselves together so that they do close. You have to put them on notice. Or if they don't, if you do serve and they don't comply, then you can hold them in breach of contract and you could sue them. and you really could. You have rights under the law to hold them in breach and to sue them. Does that happen? Not often, because suing costs a lot of money. So usually time of the essence letters are used as threats, but they should be used when appropriate. They shouldn't be thrown around when it's not appropriate, and they shouldn't be abused, but it is a tool that can be used, and it does put people under pressure. So it's a strategy when you're in a residential transaction to use them. Again, if you're buying an REO property, depending on the seller, they might like automatically decide that you missed the closing date. They don't want to work with you anymore. They might want to keep your deposit. Like it really depends on the terms that you negotiate. Every transaction is specific. Every term gets negotiated on each and every deal. So there's no cookie cutter approach. But this was just to give you a high level discussion about what it is, why it comes up, how it's used, when it's used, and to give you an opportunity to ask me some questions in the comments if you do have any. And happy Monday night, and thank you for listening. And I look forward to recording another video for you tomorrow.